A man stands at the edge of his own property. Behind him, barren, trampled earth. Ahead, a locked gate that's been cut open more times than he can count. The land is his. The problem is, nobody else seems to believe it. This is the story of property ownership in Northern Ireland, where a man's right to build on his own inheritance became the least important thing in a dispute that would consume 3 planning applications, countless neighbors, and one increasingly desperate legal situation. The question at the heart of this case is deceptively simple. Can 20 surrounding households collectively prevent one man from developing his own land? And more troubling still, can they use that land as their own recreational space while doing so? The backstory begins not with conflict, but with inheritance. In 2018, the man's father, a farmer with properties scattered across Northern Ireland, obtained planning permission to construct 4 houses on a large field. The permission was granted. The paperwork was in order. Everything should have proceeded as planned, but life intervened. The father required nursing care. The building project was abandoned. 5 years passed. In 2023, the planning permission expired quietly, the way most bureaucratic allowances do, without fanfare, without ceremony, simply ceasing to exist. The man inherited the field. What he thought was straightforward ownership became immediately complicated. The field was surrounded on 3 sides by residential properties. Beyond his boundary fences lived families. Beyond those families lived more families. A community had grown up around this piece of land, and that community, it would turn out, had developed expectations about what that land should be. The first planning application arrived in the system with confidence. Permission to build 3 houses. A modest proposal. A reasonable use of inherited property. The objections came like a storm. They weren't random. They were organized, deliberate, and they arrived in significant numbers. From all 3 surrounding sides, neighbors filed formal complaints. The grounds were specific, residential amenity. That phrase would become the hammer used to reject every subsequent application. But beneath that legal terminology lay a more human objection. These neighbors were using the field. Their children played football there. The grass was unmarked, free, open, a recreational space that belonged to no one in particular, which meant it belonged to everyone. Or so they believed. The dogs came next in the narrative. Multiple households, it became clear, had developed a habit of letting their animals loose within the field boundaries, without permission, without restraint, without consideration for what the actual owner might want to do with his own land. The property was being used as a public park by people who lived around it. Nobody paid rent. Nobody asked permission. Nobody acknowledged that the field had an owner with rights and intentions of his own. When the padlock was installed on the gate, it seemed like a reasonable response. A basic assertion of property rights. I own this land, therefore I control access to this land, but the padlock did not remain. Someone cut it off with bolt cutters. The gate stood open again. The message was clear though unstated. Your ownership means nothing here. This place belongs to us now. This happened repeatedly. A new lock, bolt cutters, an open gate. The cycle became a metaphor for the entire dispute. The property owner attempting to exercise basic rights, the community rejecting those assertions, and the law appearing unable or unwilling to intervene in any meaningful way. The application was rejected. The second application arrived with reduced ambitions. 2 houses instead of 3. Perhaps compromise would work. Perhaps scaling back the development would address the concerns about residential amenity, that catch-all phrase the planning committee had used to justify the first refusal. The same neighbors objected. Different numbers on the application, identical reasons for rejection. Residential amenity. But now something more insidious had become apparent. The field was deteriorating, not from natural causes, but from deliberate use. Dog excrement accumulated to such levels that it killed vegetation. Studded football boots, tore the ground apart in patterns that matched no farming use, no constructive purpose, only recreational damage. The field was being destroyed by the very people claiming they wanted to preserve it. The third application was a last attempt. One large house, the smallest possible footprint on the market, a single dwelling on land that planning permission had once allowed for 4. It was rejected too. The neighbors mounted their objections with the confidence of people who had won twice already. Residential amenity. Always residential amenity. The planning committee upheld their decision, and with each rejection, a question emerged that nobody seemed to want to answer directly. If neighbors can prevent development through collective objection, what does property ownership actually mean? What rights does an owner retain when surrounding residents decide those rights are inconvenient? The property owner was now facing a legal paradox. He could not build, but neither could he exclude people from his land. Every attempt to secure the boundary, the padlocks, the gates, the assertions of ownership was met with either destruction or simply being ignored. 20 households were simultaneously denying him the right to develop his inheritance while claiming the right to use that inheritance as they saw fit. The dogs continued to be let loose. The children continued to play. The litter accumulated. The grass was torn to pieces. And the man stood at the edge of his own field, locked out by law, locked out by planning, locked out by the sheer weight of neighborhood opposition. What happens next remains unclear. The planning appeals process exists, but 3 rejections suggest a troubling pattern. The courts could theoretically be engaged to remove trespassers and enforce property boundaries, but against 20 families. The practical, financial, and social toll of that litigation would be immense. The field remains, the owner remains, the neighbors remain, and somewhere in that deadlock lies a question about rights that British law has not yet fully answered. Who really owns the land?